Note that this content is for adults only. Viewer discretion advised. If you haven't yet, hit the subscribe, like, and share. Hello everyone and welcome back to another live stream with me, Gisela K. This is Grizzly True Crime and today we are here to discuss the Delphi case. If you were with me already on this day, you know that we had a take one of this exact stream. So I'm just going to recap what we went over there because it was buffering so badly that I just decided to start another stream. So whether that is YouTube glitching or internet or I don't know what, Switzerland, I don't know. But here we are, let's try again. Okay, I really hope it works out. Let's go. So what we did, okay, welcome to all my moderators, patrons, members, and everyone. Thank you for being here. Thanks for being patient. So here we go. What we're doing is going through this motion to compel and motion for sanctions, which is a very interesting document. And at the point at which it got really interesting, yeah, I have to start over. So let's do that. So firstly, today we went over the following. So I'm just going to recap because that other stream, yeah, that's got to go. So the thing is that an entire media coalition asked Judge Gall if they could please cover this trial. Okay, can they have even just audio only? And Judge Gall, of course, said denied. Also, there was an email that a concerned citizen wrote to Judge Gall, but this time asking for no cameras in the courtroom and no audio because they think that YouTubers, podcasters, and whoever will just twist whatever they learn there. Okay? So, you guys are like, here for take two. Now, okay, so now we've gone over the motion to suppress the accused's second statement. I'm going to recap it, okay? And so what this is the defense asking that Richard Allen's statements are suppressed from his second interrogation. And so we can go over this later, just to recap if you did miss it. Now, McClelland is saying objection to that. He doesn't want those statements to be suppressed, which these are very normal things we would see leading up to a trial for the defense to be asking for their clients' self-incriminating statements or confessions to be suppressed, right? And then for the state to say, I object. So that's no biggie. The implication or the allegations basically are that in this interrogation, the defense is basically saying that Richard Allen was in this tiny confined room and being pressured into saying things that maybe he shouldn't have said, and that he wasn't read his Miranda rights or that they didn't record them reading him the Miranda rights, and they have no evidence of that. Okay, so that's why. Tracy, thank you so much. I really, really appreciate it. Jan says, strange thing was the glitches during the live disappeared in playback. What? Okay, well, here we are together now doing this. So then we also saw that Nicholas McClelland wants to question the credibility of Todd Click, one of the investigators who has been, he's one of three that were investigating the Odinist angle of this case. So Nicholas McClelland is, I don't know why he's doing this before the trial. He doesn't want this guy's testimony in. Maybe he thinks, oh crap, the jury will believe him because it is quite believable in my opinion. I think it could create a lot of reasonable doubt. And so he is looking into Todd Click's mental health records is what he's requesting, which I'm like, that's a bold move. You're going to ask for the mental health records and all employment records of a police officer? Okay. From Rushville. So that's what's happening here. He's requested it. He hasn't got it yet. Now, what we were doing is looking at this. So we're gonna take off from here, okay? Welcome. Steel Guitar says, it's good to be back. I agree. Now, this was filed yesterday, the 23rd of April of 2024, and it's a document filed by the defense. It says, comes now the defendant Richard Allen by counsel, Andrew Baldwin, Bradley Rosie, and Jennifer Auger, and for his motion to compel states as follows. Now, this introduction is a little timeline of what happened. You know that on October 28th of 2022, the state of Indiana, by its prosecuting attorney, Nicholas McClelland, charged Richard Allen with 2 counts of murder. His initial hearing was held October 28th of 2022, and so they go. So they talk about when this defense team was reinstated after being kicked off the case. Now, let me remind you that Judge Gull, it's 19 days to go before the trial. And she still has to rule on the contemptuous conduct hearing, which I'm so nervous about because she could actually say, okay, you know what? Yeah, I agree with the state that this was contemptuous conduct. So imagine if she tries to, or does, kick the defense team off the case again. I mean, that's a possibility. Well, that's severely going to delay the trial, of course, which is why I keep asking, do you think that this trial will really start on May 13th? Okay, CJ says, I'm so confused. Don't worry. We're just reading some new documents. Don't be confused. So here we all are. Welcome. Now, they say introduction is a little timeline, so I'm going to go forward. Here's the motion for sanctions. So it's an 11-page document. Let's start here at the motions for sanctions and why they're asking for this. And I think some of what's contained in here is pretty interesting. If what they're alleging is that basically the state is either delaying handing over discovery, which I would agree with because it's been years of investigating. They should have had everything ready to go when this defense team joined, right? The case, when they were assigned to Richard Allen. But no, it took very long to get certain things. And when they then eventually get discovery, they say in this discovery is all this out of context information. And I'm like what? Like what? So today they're going to say like what, which is very interesting. Okay. PM Kitty, is that I said? PM Kitty says, I have sent you a message on Twitter. I live in Indianapolis. Would love to attend the trial on behalf of the channel and do live updates from Fort Wayne. I will check your message later. Thank you so much. All right. Yeah. R Max says, I jump right in. Yeah. We'll pick up right where we left off. Here we go. Are we ready? Because it was getting spicy. Between September 8th of 2023 and October 6th of 2023, 9 months after it was due, the state of Indiana sent the defense 14 hard drives, 5 flash drives, 3 DVDs, and several emails containing discovery disclosures amounting to almost 4 terabytes of information. Before the defense had a chance to review all of this late discovery, utilizing only 2 lawyers and 2 non-lawyers, 3 of whom were not able to work full-time on the case, the prosecutor requested that the defense be disqualified on October 10th, right, and we know about this. Now, during those 34 days, the time frame from September 8th to October 12th, the defense was only able to review a tiny fraction of the massive amounts of discovery that's been dumped on the defense 9 to 10 months after it was due. In my opinion, and I'm not a lawyer, I think it's kind of unacceptable that it took so long. Let me just move the slide. Don't you think it took really long? Why is there a 9 to 10 month delay is what I want to know. Why? Powder Packs, it's good to see you. So I just don't have an answer for that. McClelland, why are you delaying things? You've got everything ready, no? Okay, now, however, it did not appear to the defense that the hard drives were organized the same as when originally provided during their first tenure. And these changes have caused considerable delay in locating certain evidence, if that evidence can be located at all. Additionally, it appears to the defense that the state of Indiana has belatedly disclosed tens of thousands of documents spread through many hard drives. For example, the state of Indiana first turned over the hard drive labeled FBI case, and there's a long number there, to the defense on 10/31/2023, after Rosie and Baldwin were off the case. And the state of Indiana turned over the hard drive labeled Orion to the defense on 12/7/2023, after Rosie and Baldwin were off the case, right? Okay, so everything's late, we know that, but let's see what else was in this discovery. So that's what I'm trying to get to. While the defense should have had those hard drives on or before December 14th of 2022, the defense did not receive those hard drives until January 30th of 2023. Most of the items found on the hard drives detailed above are not labeled in any descriptive fashion, and many, if not most of the items consisting of documents, photographs, and video have zero context as to what the significance of the documents or video photographs are. Many of the items are not accompanied by a report or even notes that explain the reason such items are included in the discovery. For example, one video shows a man that appears to be dead on a bed being turned over by what appear to be the police. There's no context provided as to why that video is included in the massive amount of discovery or why this video has to do with the murders of LG and AW. That's just one example of thousands of examples the defense could cite of evidence with no context of why it is related to this case that the state of Indiana has provided to the defense. Additionally, more recent evidence that the state of Indiana has turned over to the defense through e-discovery contains evidence that is seemingly sandwiched in the middle of completely unrelated discovery. It's just a bit odd, isn't it? Okay. I mean, I do want to know as well. Don't you want to know? Why is there, I wonder if the guy is actually a deceased person, or are they just saying it? Are they just saying, well, it looks to be like someone deceased in a bed that the police are turning over? Because that's just weird. Very, very strange. Okay, let me just quickly, I don't want to confuse people, so I just want to actually, where is this? Just wait. I'm going to just delete this previous stream so that people don't get lost over there and they come over here. Okay, please like and share so that others know we are live again right now. Okay, so now listen. The state produced, okay, sandwiched in the middle. For example, the state produced one e-discovery response received on March 15th of 2024, which included a document labeled Second Half of Delphi, 3 subs, consisting of 341 pages of documents. Most of the contents of this document are reports from Westville Correctional Unit. However, buried among these other reports is a narrative report on page 239 by Detective Vito of the ISP, describing a phone call with a Detective Liddell of the Manatee County, Florida Sheriff's Office, detailing an investigation of a third-party suspect known by Unified Command in this matter. Now, what is going on there? Right? Scully, thank you for being a member for 17 months. Lily Pauly says, I lost my jacket in the portal. I did. Okay. I had to just have it talking to my computer, and that required my jacket to be taken off. Okay, so I'd love to know more about all of this as well, because who are they talking about over here? I see speculation on X. I've seen it, and I'm like, oh, very interesting. So I'm not going to repeat it here now because I just don't know. But let's keep reading. So they say, buried among these other reports is a narrative report on page 239 by Detective Vito of the ISP, describing a phone call with a Detective Liddell of the Manatee County, Florida Sheriff's Office, detailing an investigation of a third-party suspect known by Unified Command in this matter. Detective Liddell told Detective Vito that the Manatee County Sheriff's Office sent a tech to obtain a pair of a suspect's jeans that appeared to have blood on them, and that Manatee County Sheriffs would send the items to the Lafayette, Indiana State Police Post. Additionally, Detective Liddell sent an email to Detective Vito with their report and a statement affidavit. Detective Vito noted that both documents were attached to the report. Neither the Manatee County, Florida report nor the statement affidavit were attached to the document the state of Indiana provided to the defense. The defense has not located any follow-up discovery detailing whether the state of Indiana even attempted to test the blood on those pants for DNA, and does not know if such a report exists, and if it does, whether it may be found sandwiched in between other discovery. This is just another example of the discovery issues plaguing the defense. This document would not have been found but for someone taking the time to go through this discovery one page at a time. Oh, I wish that were me going through that discovery one page at a time. But I love documents, okay? I could help. So Amy says, love your coverage of these crimes or trials. Your defluffing is fantastic. Oh, thank you so much. Okay. So Lutina B says, wait, what? Manatee County, Florida, that's where I'm from. So I do find that interesting. A third-party suspect? What do they talk about? Suspect. All right. Anyway. Furthermore, the state of Indiana has sent repeated piecemeal discovery, forcing the defense to engage in a time-consuming process of reviewing and attempting to search multiple hard drives, flash drives, and e-discovery for particular documents the defense believes exist but cannot locate. the state of Indiana has drowned the defense in late discovery disclosures, which materially harms the defense team in preparing for trial in a meaningful and cohesive way. LG's cell phone. That's, of course, one of the victims, Libby German, right? Okay, so on February 15th of 2017, Lieutenant Brian Bunner of the Cybercrimes Unit of the Indiana State Police conducted an extraction of data from LG's cell phone using a program called Celebrite. Now, if you watch trials with me, you know, they always talk about Celebrite, right? Okay, so said information was downloaded via Celebrite and several reports were generated therefrom. When the defense was unable to locate in discovery the data from LG's phone, it sent an email to Prosecutor McClelland on June 17th of 2023 requesting a copy of that data from LG's phone as it had not yet been provided to the defense. Which again, I'm thinking, isn't that really important evidence to have in the discovery file? Why can the defense not see that? I don't know. Okay. Clearly, the state of Indiana possessed the 2017 Celebrite extraction and data on the date that they filed charges against Mr. Allen, October 28th of 2022, as well as when the defense requested the data from LG's phone in its June 17th, 2023 email. Despite being in the state of Indiana's possession for over 5 years, when charges were filed against Mr. Allen on October 28th of 2022, the extraction and data from LG's phone was not provided to Mr. Allen's attorneys until September 8th of 2023, 9 months after it was due to the defense. Okay. Rob's like, Celebrite, good times, come on. The true crime version of that song, right? I think that would extract a lot of data, which will be interesting if they have conversations between LG and Keg and Klein. Okay, so here they say, however, even upon receiving the extraction and data from LG's phone, the defense was unable to immediately focus on that important piece of evidence, as that evidence was just one small part of a much larger series of evidence dumps the state of Indiana chose to turn over to the defense in a roughly 4-week period between September 8th of 2023 and October 6th of 2023, more than 9 months later than required under the Indiana Rules of Criminal Procedure. Included in the 2017 Celebrite extraction of LG's phone was a video purportedly taken on February 13th, 2017 at 2:13 p.m., containing images of AW and a purported suspect. The state of Indiana failed to produce this extraction to the defense until September 8th of 2023, 9 months later than the discovery rules mandated. Okay. Additionally, in 2019, the Indiana State Police, perhaps with outside assistance, conducted additional extractions of LG's phone. All right, in 2019. Additional extractions of LG's phone utilizing different software programs. These newer extractions have been discussed by Indiana State Police officers in depositions, but has not been located in any discovery provided by the prosecutor in any usable fashion. The defense has requested the state of Indiana to provide the locations of these newer extractions. Additionally, a certain extraction software program called Axiom has been provided to the defense. The defense has been unable to open said extraction, but apparently needs some type of special license program in order to open the extraction. The defense believes that the state of Indiana has not provided the special program. Dude, I think you could probably download the program. Not? They're like, we need a special program. Okay. Looking for tech advice in that moment. They're just like, how do we open this? Okay, so they want the state to provide that. Now, as part of a reasonable investigation, the defense would have wanted the opportunity to compare the 2017 extraction to the 2019 extraction and see what differences might exist and the reasons for those differences, and would have further wanted to exercise that opportunity on or before December 14th of 2022, when the state of Indiana was required to turn over all extractions of LG's phone so that the defense has had time, as much time as possible, to analyze LG's phone extractions. There is no justification for submitting the 2017 cell phone extraction or any other of the extractions and data 9 months after they were due to the defense, especially when the state of Indiana has had the evidence in its possession for almost 6 years prior to charging Mr. Allen. Do you agree with that? Because I do. I don't think there's any reason to delay it like that. Why is it so late, right? Or Mac 2x says, The Indiana Supreme Court justices must be cringing at how this case is being handled. Court decorum, indeed everywhere in the country, prevents the higher courts from taking the initiative to intervene. Janet's like, it's been denied. Whatever it is, yes, it's denied. Okay, so unless, of course, it's McClelland asking for something, then, you know, things take longer. Like Judge Gold still needing to rule on the contemptuous conduct. Normally that would be like, yeah, denied. But now it's like, oh, okay, let's just look into this for a little bit longer. 19 days before trial, we still don't have an answer. Stefan's like, we need this acrobat thing. Freaking acrobat. What do we need? How do we open these extractions? Okay, sorry about that. So, Assistant Rushville Police Chief Todd, otherwise known by McClelland as Toddy Click, if you were at the first live stream, Todd Click's letter, report, and evidence. Now, remember, Todd Click is one of 3 investigators that were investigating the Odinist angle in this case. Okay, so McClelland wants to check out his credibility and mental health records, as we just discussed. One of the 3 has been murdered, so that's concerning as well. We've gone over that before, so check out the playlist if you've never heard of this case or you've never seen any of that or any of the coverage that you might want to catch up on, right? So Cherry says, if I was the defense, I'd misfile something by saying it came from McClelland just to watch it get approved so they can prove Gold's bias. You know, there's a letter, as I said earlier in the live stream here, that somebody called James sent to Judge Gold to say, please don't allow cameras in this courtroom. And for a moment there, I thought, oh, that's so smart because she denies everything. So what we need to ask for is, please don't have cameras. We don't want any cameras in the courtroom. No audio. Totally closed door. The opposite of transparency. Maybe she'll deny that. And then there you go. There will be cameras in the courtroom. Reverse psychology that, you know. So they say Assistant Rushville Police Chief Todd Click letter, report, and evidence. Contained in these disclosures was the letter, an 83-page report, I wish I could see that, prepared by Assistant Rushville Police Chief Todd Click, hereinafter Click Report, which was sent by certified mail to Prosecutor Nicholas McClelland on April 28th of 2023. Hello. Fury says hello. The Carroll County Prosecutor's Office signed for the certified letter and report on May 1st of 2023. Yet, inexplicably, Mr. McClelland did not disclose this highly exculpatory report, nor the accompanying exculpatory videos and other related discovery to the defense until September 8th of 2023, 4 months after he received it. Rule 3.8d of the Rules of Professional Conduct, Special Responsibilities of a Prosecutor, states that the prosecutor in a criminal case shall make timely disclosure to the defense of all evidence or information known to the prosecutor that tends to negate the guilt of the accused or mitigate the offense. The prosecution should have turned that material over to the defense immediately upon his receipt of the same. Jerry says, we've got Tricky Nicky and now we've got Toddy Clicky. Right? Slick Nick. Tricky Nicky. Oh man, okay. Yeah, that's what the case has come down to. We're down to nicknames now. Okay, so I really hope this trial does start on May 13th. I really do, because I just have a bad feeling it's not going to. It almost feels like there'll never be a trial, but I really hope I'm wrong. Okay, so, and let's hope it's a fair one, and all of that. So, there's no justification, which I agree with, for Prosecutor McClelland to delay turning over the Click report for over 4 months after the Carroll County Prosecutor's Office received it. The delay in disclosing the Click report and evidence to the defense has resulted in harm to Mr. Allen. Had the state of Indiana turned over the Click report, videos, and documentation in a timely manner, the defense would have focused on certain third-party suspects much earlier in their representation and would have then investigated this case much differently and much more efficiently. Changed the order of deposing witnesses and would have deposed certain witnesses such as Elvis Fields, Brad Holder, Johnny Messer, Rod Abrams, Ned Smith, Patrick Westphal, and Taylor Hornaday much earlier. I'm still amazed that they just named these people just like that. Okay, they just put in all these documents just like, this is who we think did it. Like, wow. I don't know. Have we seen that in other cases? For example, in the Gilgo murders case, Long Island serial killer case, you hear that the defense is like, we want to know about these other POIs, but they don't normally just like name people, but okay. Especially not publicly, but all right. Okay, ask different questions of law enforcement at their depositions and been better prepared for trial earlier. So Are you getting the feeling that the defense is now putting the brakes on a little bit, or no? Because they were wanting a speedy trial. They were wanting it later as well when they got reinstated. Like, let's go January 12th. They've always said that they are ready to go, which we don't normally see with defense teams. Normally it would be the defense delaying things, right? In general, I'm generalizing. But in this case, the defense was like, go, go, go. But now I feel like 19 days away. Is everybody ready? The terms of Mr. Allen's imprisonment and early trial considerations. So here we go, deep breaths. We're on page 6 of 11. The fact that Richard Allen remains trapped in solitary confinement in the secured housing unit of both Westville Correctional Facility and the Wabash Valley Correctional Facility while on pretrial detention has caused a physical and mental deterioration of Mr. Allen, causing defense counsel to seek a speedy trial rather than risk their client facing further mental and physical deterioration. The fact that the state of Indiana has violated rules of discovery through very late disclosure of large volumes of evidence, including evidence that supports the theories of innocence, has put the defense in a precarious position where it could have, 1, kept the October 2024 trial date. Yeah, 2024? Trial date. And then spent the next 6 to 8 months reviewing late evidence that the state of Indiana had in its possession at the risk of continued deterioration of their client's physical and mental well-being, or 2, seek a speedy trial and hope that they can put the case together in spite of the significant discovery violations perpetuated by the state that have put the defense at least 9 to 10 months behind where it should have been had the state of Indiana followed the rules. Okay, now while I think I'm not glitching, the chat certainly is. I can barely see the chat refreshing, so I'm sorry if I miss any of your comments. I will look at them all afterwards. Please leave some comments below as well, okay, after the live stream is done. Now, as a basis for understanding the impact of solitary confinement for even 2 weeks on a human being, let alone 16 plus months, the defense cites the United Nations finding on that topic. So I'm just going to keep going because, of course, we've gone over a lot of this before, right? We know it would be terrible to be in solitary confinement for very long. Janine Tavalia says, the defense team is playing psychological games. They pretended that they wanted a speedy trial to get back into the case. Now they'll drag everything out. Nothing will surprise me. Nothing. Dab says, doesn't sound like they'll be ready in 19 days. I don't think so. I don't know, man. I don't know what's going to happen in this case. Oh my goodness. The decision to seek a speedy trial was not hastily made, but only decided after factoring in that Richard Allen has been languishing in solitary confinement for well over a year. Okay, approximately 536 days or 521 days longer than allowed by the United Nations, which equates to more than 20 times the standards set out by the United Nations, and continues to suffer both mentally and physically. The defense fears that delaying the trial will result in continued and prolonged mental and physical trauma to Richard Allen, or even worse. Choosing a speedy trial and dealing as best it can with the fallout from the state of Indiana's late discovery disclosures was, and still is, a better option than risking Richard Allen's well-being by prolonging the trial date to October. CJ says this man is going to be a millionaire after he sues. It's all documented if he survives. Rob says, I'm concerned this trial will not be fair. Cameras not allowed in the courtroom. Make this case sound more sus. Yeah, I mean, I know there are many trials where they don't have cameras in the courtroom, but it's just odd because, as far as I understand, Judge Gohl was one of the judges in Indiana who wanted live streaming of trials, who wanted cameras in the courtroom, was one of the people that fought for it, and now doesn't want it. I don't know. I don't understand why not, Anyway, there are many trials that we don't get to see. Sometimes I'm very interested in a case and I'm like, oh my word, are there going to be cameras? Are they going to stream it? And then, you call and they say, nope, sorry. Nope, this is not going to be covered. Like, okay. So, request for sanctions. As a sanction for the belated disclosure of the report drafted by Assistant Rushville Police Chief Todd Click, the defense requests that the jury be instructed that Assistant Chief Click's report contains evidence tending to prove the innocence of Mr. Allen and that the prosecution failed to turn over that evidence to the defense in a timely manner. I mean, I don't see that ever happening. They're like, you know what's going to happen now? You're going to tell the jury. And I'm like, I don't see it happening like that, but okay, they got to try. And so, further, the defense requests that the state of Indiana be excluded from rebutting any information, presented by the defense, and contained in Assistant Chief Click's report and accompanying videotape statements. So the state of Indiana must be excluded from rebutting any information. We want Todd Click to speak. He's our witness. He will not be questioned. No rebuttals. What? Okay. Never going to happen, in my opinion. What do you think? Now, Onyx says, this of all cases needs the transparency, in my opinion. I agree. So, yeah, of all cases that we've ever seen, this one definitely. As a last sanction for the delayed discovery of the Click information, the defense requests that it be able to play the late discovered video evidence of any witness it chooses to the jury without objection from the state of Indiana, foundationally or otherwise. Indiana Trial Rule 37.2b states that if a party fails to obey an order to provide or permit discovery, the court in which the action is pending may make such orders in regard to the failure as are just, including prohibiting it from introducing designate matters in evidence. As a sanction for the late discovery or non-discovery, Mr. Allen requests that all data from LG's phone, including video, from all data extractions be excluded from evidence. Interesting. I don't know, man. That makes me feel like, what do they have on Richard Allen? What do they have? Okay. I just need to quickly say something here. Okay, there we go. So, that's it. They suppress all confessions, self-incriminating statements, and also all the data from Liberty German's phone, including video from all data extractions. They want to exclude the bridge guy video? Yeah. Okay. That's never going to happen. Motion. Imagine if Judge Gold was like, okay, yes. That'll be even weirder. And as I say, nothing will shock me in this case. Now, motion to compel. Additionally, the defense believes that there are multiple documents which still have not been disclosed to the defense, or that the defense cannot locate in the massive discovery provided to the defense. This includes the following. On November 4th of 2019, the state of Indiana sent a geofence warrant to Google requesting activity from any device in a specified distance and within a specified time of the area in which the bodies of AW and LG were located. On the same day, it appears that Google, Uncle Google, returned data in a spreadsheet which contains 18,632 lines of data, each relating to a particular device ID. Generally, there's information received to follow-up requests which identify subscriber data with device IDs. To date, no such spreadsheet or data has been located by the defense, nor can any such information be found by the defense in spite of requests to the prosecution. Detective Murphy testified in his deposition that law enforcement had pings and other phone information related to Elvis Fields' phone. Okay. That's one of the alleged Odinist guys. The one that said, if you find my spit on one of the girls, okay, and I can explain it away, am I still going to be in trouble? That one. Another one who confessed. Very odd, all of that. Very odd. So, when they say Detective Murphy testified in his deposition that law enforcement had pings and other phone information related to Elvis Fields' phone on that day, 2/13/2017, to date, no such data has been located by the defense, or the defense cannot locate that information in the massive discovery dump, despite good faith efforts to locate said evidence if it exists. They had pings. Okay, but where were the pings? Where were the pings? Just hold on 1 second. Wait. Ooh, the cats are being naughty today. SOPs for evidence collection and retention for Indiana State Police, Carroll County Sheriff's Department, and Delphi Police Department. To date, either no such documents have been provided or the defense cannot locate that information in spite of requesting said information from the state of Indiana. Right, Stefan? They need that acrobat thing. I can hear it. They want to open these documents. Okay, so chain of custody documents related to the bullet purportedly found near the bodies of LG and AW. To date, no such data has been located by the defense, or the defense cannot locate that information in spite of requesting said information from the state of Indiana. Chain of custody documents related to the sticks, branches, and bark found at the scene. To date, no such data has been located by the defense, or the defense cannot locate the information in spite of requesting said information from the state of Indiana. The defense possesses photographs of the bullet purportedly found in the ground near the bodies of LG and AW, and photographs of the bullet at the crime lab. Now, why was it in the ground? It's weird, this case. Okay, the defense has no other photographs or video of the bullet from any other time. In the event that there are additional photographs or videos, the defense requests they be immediately produced. To date, no such photographs have been provided to the defense, or the defense cannot locate said photographs in spite of requesting the state of Indiana to point out where said photographs are located in the discovery. If no such photographs exist, then the defense would request that the prosecution affirmatively state that no such photograph exists. Then, prior to October 19th of 2023, the state of Indiana previously provided the defense a number of PowerPoint presentations, which were titled executive briefs or summaries, which appear to be presentations providing information to law enforcement during briefings, including a PowerPoint presentation connecting Elvis Fields to Delphi. To date, since getting back on the case, no such data has been located by the defense, or the defense cannot locate that information in spite of requesting said information from the state of Indiana. Wow. DP says bullet was stepped on and in the dirt. Could be an option. Fromplefeet says someone planted it there and stepped on it. Jennifer says, can you please send Fury to Indiana and get this mess straightened out? Fury. He's got to go. So I don't know why they can't find these files now that they had before. Okay. According to certain law enforcement officers involved in the investigation who have been deposed, members of the FBI Behavioral Analysis Unit, BAU, were present and engaged in the investigation of this crime. References have been made to BAU reports. However, the defense has not been able to locate any reports from the BAU agents or any other law enforcement concerning assessments of the crime scene regarding Odinism, Nordic culture, or paganism, Germanic culture, runes, magic, cult activity, or heathenism. To date, no such data has been located by the defense, or the defense cannot locate that information in spite of requesting said information from the state of Indiana. Now, Lorraine says the bullet could have already been there from before. This guy lives in Delphi and often walked on the bridge. That's true, but unfortunately, it sounds like in his interrogation, he didn't say that. He should have then said, well, I was there a lot. If you found a bullet from my gun there, well, I used to walk there a lot. But he didn't say that. So on April 16th of 2024, pursuant to the Indiana TR 26F, Defense Counsel sent a letter to Prosecutor McClelland via certified mail and email requesting the above information, paragraph 36A to H, or the identification of the location of the information in discovery if it had been previously discovered. Furthermore, Defense Counsel requested a response by Friday, April 19th of 2024. Yeah, that's come and gone. In its April 16th, 2024 certified letter to the prosecutor, the defense requested that the prosecutor A. explain the reasons for failing to turn over the exculpatory click information for 4 months when that Brady material should have been turned over immediately to the defense upon receipt. 2. Explain his September 6th, 2023 email in which he, the prosecutor, made false claims and misrepresentations to the defense concerning the identity of a Purdue professor and law enforcement's attempts to locate said identity, even going as far as telling the defense that the state of Indiana may not be able to learn the identity when at the time of the email, the identity was already known. 3. Explain the reasons for dumping 14 hard drives, 5 flash drives, 3 DVDs, and certain e-discovery 9 months later than required under statute, and thereby putting the defense at a distinct disadvantage, especially while dealing with their client's mental and physical health issues which propelled their request for a speedy trial. Okay. The defense requests the court to order the prosecutor to explain his conduct around the issues raised in paragraph 37 above. It's very interesting that all this is happening while Judge Gold still has to decide on the contemptuous conduct hearing that happened on March 18th. It's a while ago. Right, so the state of Indiana has made no substantive response to the discovery deficiencies outlined in the defense's April 16, 2024 letter, nor has the prosecutor attempted to address the issues outlined in paragraph 37 herein. Additionally, in early April, the defense requested the prosecution to provide Brady Giglio material, if it exists, concerning certain law enforcement officials, both state and federal. The defense provided a deadline of April 15th of 2024 for said Brady Giglio material, then extended the deadline to April 19th. To date, the prosecution has failed to provide any Brady Giglio material, nor has the state of Indiana indicated that no such material exists. The defense believes that at least one key member of law enforcement has Brady Giglio material that the state of Indiana has failed to turn over to the defense. Wherefore, the defendant Richard Allen, by counsel, respectfully requests the following. A, that the above documents be produced to counsel for the defendant by 5 p.m. Friday, April 25th, 2024. But we know that the prosecutor only likes to file things at like 10 p.m., so 5 p.m. is a bit early, hey? Okay, so let's hope they can produce whatever they need here. The state of Indiana be ordered to turn over Brady Giglio material to the defense by 5 p.m. Friday, April 25th, 2024. That the state of Indiana be sanctioned for its discovery violations in the following way. This court will instruct the jury that the prosecution received certain evidence that tended to exonerate the defendant on May 1st of 2023, but failed to turn over that evidence for over 4 months, and that said failure to timely produce that evidence to the defense was a violation of the rules. Permit the defense to play any video that was belatedly produced without objection from the state of Indiana. Prevent the prosecution from rebutting the evidence that Todd Click provided to the prosecution on May 1st of 2023, and prevent the prosecution from using any data or information extracted from Liberty German's phone in its evidentiary presentation. I mean, that's just... what a request. All of that, we want it out. I'm saying, like, wow, even all the information on Libby's phone? Sure. Purple AJ says, a lot of these requests are to save for appeal. I know. Thank you so much. Then, that the prosecutor, well, yeah, I think they're doing a good job as defense attorneys. So, that the prosecutor be ordered to explain in written form his reasons for delaying it and all the stuff we've just gone over for all and other proper relief, and they signed it there. So, that is that document. Now, because the previous stream did not work out with all whatever glitches it was, we have now not together discussed. Okay, so now we've caught up, okay? So now let's just look at this interrogation again. One more time. Apparently, Richard Allen had police interviews, of course, and the defense has a problem with the second interrogation because they say he was not read his Miranda rights. Okay? Rob says, even if he's found guilty, an appeal may be successful. You have a good point. I think there's a lot of reasonable doubt in this case, and I think that an appeal is also possible, as you say, Rob, based on everything we're reading. All right. So, I want to go to this second interrogation. These documents are out there, but this one is where Jerry Holman was getting all, aggressive over here. So, on October 13th of 2022, Kathy Allen, Rick's wife, and Rick Allen asked the state police when they could pick up their vehicle that had been seized. They were told they could pick it up in a couple of days. On October 17th, 2022, either Kathy or Rick contacted the state police to determine how and when they could get their vehicle back that had been seized, as they were in need of that vehicle, as Kathy and Rick were having difficulty sharing only one vehicle as they worked in 2 different places and needed 2 vehicles. After a few phone calls with the state police, finally on October 26th, Rick and Kathy were scheduled to arrive at the state police post in West Lafayette at 9 a.m. to pick up their vehicle. On October 26th of 2022, Rick Allen drove with Kathy to the West Lafayette post to retrieve their vehicle that had been seized 13 days earlier by law enforcement. Did he have to be there? Did Richard Allen have to be there that day to pick up that vehicle? Because what's interesting is if he felt like, oh crap, they're onto me, if he's in fact, the right guy that they have, let's say, who's innocent or proven guilty. I'm just saying, if he was like, oh no, I've already been interviewed, they're onto me, I'm not going to go with you, go pick up the vehicle. Right? But no, he went along. Okay. Also, making sure, maybe, I'm just thinking out the box. Why would things have happened the way they did here? Maybe also being like, I'm just going to comply so I don't look sus, if he is in fact the right suspect. which I know many of us have our doubts, right? State police had told Rick and Kathy that upon arrival, their car would be released, but they never mentioned anything about additional questioning. When Rick and Kathy arrived at the station, Holman met them at the front and said that he just had just a few things he wanted to clear up before he released the vehicle. Holman requested Rick to follow him. It's like, follow me to the interrogation room without Kathy. Rick complied. Kathy was not allowed to participate in the questioning. She was told that she could wait in the lobby. Now, as we read this, please let me know if you think, do you think that this guy is a patsy? Was he cornered? Was he coerced? Do they have the wrong guy? Did they set him up? Did they frame him? One of my questions would be if they framed him or they targeted him or whatever. Why him? Why him? That question I do not know. Why not Ron Logan, Kegan Kline, Tony Kline, all the others they've investigated? You know what I mean? Or was Richard Allen there that day on the bridge? Could he be bridge guy? Even if he's bridge guy, even if he said down the hill, how does one know that he's then the killer? You know what I mean? You don't know. And I still think there's more people involved, in my opinion. But who knows what will come out of this trial? So I'm always keen, especially in this case. My goodness, as things go, I would love to hear your thoughts, right? So leave a comment below if you're watching now or the replay, whenever. I can't wait to read what you guys think about this. So here we go. Kathy was not allowed to participate. She was told she could wait in the lobby. Rick arrived with Holman into the interview room, right? However, for unknown reasons, now this one, I don't know why that is. For unknown reasons, the video provided to the defense is missing the beginning portion of the interview when procedural matters are typically handled by law enforcement, such as the reading of Miranda, advisement of rights, and confirming with the suspect that he's free to leave if in fact the suspect is free to leave. In this case, either the camera was only turned on after Holman and Rick were already minutes into the interview because the video provided to the defense does not show them entering the room, sitting down, beginning the interrogation, or B, the camera was recording the entire time, but the beginning of the interview was later edited before being turned over to the defense in February 2024. Which one do you think it is? I know we don't know. Which one do you think it is? Yeah, Kat says if they just wanted to close the case, blame Logan, easy case close. Right? KT says, I think he was an easy patsy. I mean, could be just based on confession or self-incriminating statements. And then it snowballs from there. So that's possible. Right. So in this case, which one? I would think that maybe they turned the camera on late, editing out the beginning portion. I mean, imagine if they did that. Either way, the beginning of the interaction between Holman and Rick in the interrogation room, when introductions are typically made and Miranda rights are always reviewed, is missing. In the 70+ years of experience between co-counsels, this is highly unusual, especially on a high-profile case of this nature. The defense has not been provided with any report claiming this missing part of the video. To make matters more suspicious, Holman claims in his November 1st, 2022 report, memorializing his October 26th interrogation of Rick Allen, the following. I asked Mr. Allen if he remembered the other detectives reading him his Miranda rights, and he said yes. I told him he was free to go at any time and that the door was unlocked. Well, I don't know. Why not just read him his Miranda rights? You know, it's always in this case, follow procedure, follow the checklist, do your job, do what you got to do, because otherwise this could really, for example, if you think of just the police procedure, this could bite the police in the ass if they don't do that, right? Just do that. Instead of saying, hey, you remember when other people read it to you? Yeah, same. Okay, let's go. So, Rob says, is the sniffler involved? Sniffles. Okay, so Holman's, wait. Yeah, I told him he was free to go at any time. The door was unlocked. Holman's report doesn't identify who the other investigators are that purportedly reviewed Miranda rights with Rick. Holman's report doesn't detail when, where, or how these purported investigators purportedly reviewed Miranda with Rick. Holman's words, quoted in paragraph 23 above, appear nowhere on the video. In other words, Holman is not shown asking Rick Allen about his rights, nor is Holman viewed telling Rick Allen that he's free to leave. In his report, Holman indicates that those words were stated to Rick Allen at the very beginning of the interview. The beginning of the interview is missing. The defense has diligently searched through the discovery for any Miranda or waiver of rights form signed by Rick Allen on October 26th of 2022. The defense has found none. So, That's not good. Cherry said, when they read you your Miranda, they're supposed to have you sign a waiver. So where's that? That's the question. That's why they're saying, even if they say, okay, well, we didn't record it, we got recorded late, but isn't he supposed to sign a form, right? Scott says, I don't think they would edit it. Editing can be visible in the metadata. Good point, Scott H. That's what I was thinking as well. Editing it? I don't know. They'd be so busted for that. So I don't think edit it. I think they then started the cameras late. Or just really didn't read him his rights. Which is a problem. So the defense has searched through discovery for any reports by state troopers who were on duty that day, such as Jay Harper and David Vito, who would have potentially read Rick his Miranda rights on October 26th of 2022. The defense has found no such reports, just as Brad Holder's February 17th, 2017 interview is missing, just as the mimicked crime scene found on Holder's social media page is missing, and still has not been turned over to the defense, but the defense thankfully located in Georgia, and just as Rick's original taped statement to Dan Dulin in front of a grocery store in February 2017 is missing. That's also weird. That is also odd. Even the initial conversation with Dan Dulin is missing. The beginning portion of Holman's interview with Rick Allen is also missing. The defense has diligently searched through the discovery for audio or video by any law enforcement from October 26th of 2022, in which it can be seen or heard that Rick Allen was read his Miranda rights or told that he was free to leave. The defense has found none. Therefore, at this time, it appears to the defense that Jerry Holman's claims in his report that Rick Allen was asked about his Miranda rights and told he was free to leave are false, and that key video evidence that would prove as much is missing. The following are true and accurate depictions of what occurred at Allen's October 26, 2022 interrogation, as shown in the videotape of said interrogation that was not missing or deleted, but was actually provided to the defense. Thank goodness! It's amazing that they have this one, right? They lost all the others. And McClellan's like, it's not important. Doesn't matter. I mean, in those the first week, we're talking within 5 days of them finding the victims' bodies, they had interviewed these Odinist guys. Why? I still don't know why. Why? Why did you interview them? Why was the FBI at the one guy's house? Why did you call the one in? And then you just lost those interviews? That's still just strange to me. On video, Holman never read Rick Allen his Miranda rights nor mentioned them to Rick Allen. Rick Allen was placed in a tiny, confined room without windows, which that I don't think is such a shocker. Seen that in interrogations, right? Rick Allen was placed in a tiny, confined room with... and Holman shut the door. He was placed in a tiny, confined room with Jerry Holman while the door was shut. A considerable size difference existed between Rick Allen and Jerry Holman. Could be valid, could be very intimidating, I don't know. A power differential existed as Holman was a state trooper in his home court, Lafayette Police Post, while Rick Allen was a CVS worker from Delphi who had only driven to West Lafayette to pick up a vehicle that he and his wife needed for transportation. Rick Allen was never told that he was being videotaped. When Jerry Holman would leave the room, he told Rick Allen to sit tight or hang on 1 second. In other words, Jerry Holman told Rick Allen that he could not leave. So someone in the earlier live stream said sit tight was not forcing him to stay. It was very laid back Midwest folk slang. But, I mean, if a police officer tells you sit tight, just hang in there, it's more instructive than the average person saying sit tight, right? Stefan says, I don't want to be with Holman in any room. Right? Yeah, it doesn't sound great. So when Jerry Holman would leave the room and tell Rick to sit tight, he would shut the door. Jerry Holman lied to Rick Allen during the interrogation several times, including the following. It says, at 7:10, Jerry Holman told Rick Allen that we have experts that say that it's you on the bridge, and that's your voice on the video. There's no evidence that supports the statement. Jerry Holman lied to Rick Allen. At the 15:25 mark, Holman told Rick Allen that experts are saying it's you on the video, and experts are saying you said down the hill. There's no evidence that supports the statement. Jerry Holman lied to Rick Allen. At 15:07, Holman tells Rick that witnesses saw a gun in his pocket. There's no evidence that anyone claims to have seen a gun in Rick's pocket. Holman lied to Rick Allen. At 39:05, Holman says, I'm not lying to you about anything. Everything I'm telling you is fact. The experts say that you said go down the hill. Holman was lying to Rick about many things, and not everything Holman told Rick was a fact. At the 42:33 mark, Holman said, "I'm not lying to you, Rick. That's unethical." But police are allowed to lie in interrogations, right? In these police interrogations, they are allowed to get the information. There we go. Blue Bear Art says they're allowed to lie. Yes, so he told, I'm not lying to you, that's unethical. Jerry Holman told Rick Allen in what was supposed to be an exploratory interview, the prosecutor and the other investigators, they want to see you, lock you up, throw away the key. Well, yeah, we've seen that vibe. Jerry Holman barked at Rick Allen in what was... when I say barked, don't you just think of Daniel Howard, the trial we just recently watched? He's like, Jerry Holman barked at Rick Allen in what was supposed to be an exploratory interview. If you don't tell me, you're going down for this. So things started getting much more threatening there, I feel, right? Jerry Holman told Rick Allen in what was supposed to be an exploratory interview, "Do you realize the death penalty is on the table for this?" At various times, Jerry Holman yelled at Rick Allen, including using profanity-laced language while accusing Rick Allen of the murders. Rick Allen asked Holman to stop the interview. Rick said, "I'm done," early in the interrogation, at the 12:05 mark, but Holman continued his interrogation. The state police never turned over the vehicle to Kathy Allen after Rick Allen was arrested. Returning the vehicle to Rick and Kathy was merely a subterfuge to get Rick to the police post to be interrogated. Okay, so here they go over the law and everything. If you want to read over this whole document, it is available out there. I've also put it on Patreon. So let's quickly look at how that conversation went. Jerry said, "You're gonna drag your effing wife and your daughter through this because you're too effing bullheaded to get out in front of this and admit you made a mistake? And whatever the F happened out there, we'll never effing know because you're too big of a effing..." Wow. Okay. They'll never know what happened out there? Whatever the F happened out there, we'll never effing know. Are you sure? Because Doug Carter says the opposite. One day you want to know what we know, and one day you will. But here Jerry Holman's like, "We don't know whatever the F happened out there." Like, okay. Wow. So, hello to Scott Perkins. Welcome. Lorraine said people can also feel intimidated in interviews and panic. This can lead to false confessions. Happens all the time. Yes. It does happen. It does happen. So, that's why I want to hear what you guys think about this. Cherry's like, here comes the inaudible part. My mind knows exactly what he said there, right? So, Jerry Holman, "The evidence clearly indicates that you are involved in this." He doesn't say responsible for this or that you did this or that he says you are involved in this, which still the language to me sounds like, who else are you people arresting? Okay. Rick Allen says, "No." Jerry Holman, "It effing does." Rick Allen, "It doesn't. I'm telling you that there's no way that a bullet from my gun was used in these murders. One could look at that very statement there in two ways. Number one, at this point, nobody knew how the victims were murdered, which was with a sharp weapon, right? Not a gun. So if Richard Allen is innocent, he is innocent or proven guilty. But if he's completely innocent and was pushed into this confession, and he's thinking, wait, that they're implying that they have this unspent round, and so that they think that I shot them, you see? Then he says, "I'm telling you, there's no way that a bullet from my gun was used in these murders." But if you look at it on the other side, if he is the killer, that statement would also be stating the obvious, you know what I mean? Because then he would know that his gun was not used in the murder. So we'll have to wait to trial to see what happens there. So Jerry Holman says, "And I'm telling you that we've had this effing round on February 14th. I mean, is it on February 14th? Is he just saying that? Did they really have it from February 14th? Because what we've heard, which I think was from Barbara McDonald on Court TV, saying from her research that they released the crime scene and then days later came back after a civilian found this unspent round. There's that story. But here, Jerry Holman says, "I'm telling you, we've had this effing round on February 14th of 2017. It's been secured in a effing lab and we've tested other guns." Rick Allen, "You could have taken it from somewhere else then because it's not possible." Jerry Holman, "I did not take it from somewhere else. It was logged in. It was taken. It was photographed. You think we effing took a round and threw it down by the dead girl's foot?" And I hate the way he talks like that. I hate it. Okay, but it's two guys talking to each other. I get it, but that's not respectful of a police officer to speak about the victims like that, in my opinion. But okay, you think we effing took around and threw it down by the dead girl's foot. This ain't effing TV. This is realistic. Which, when he says this is realistic, I struggle to take that sentence quite seriously. He probably means this is reality. But when you say this is realistic, it sounds like this is a realistic narrative. Are you following? It's not TV, okay? Rick Allen says, I'm telling you, I can't explain something like that. Jerry Holman, and I'm telling you that effing analysts explain it. You can't get past this. Jerry Holman, I'm not on video. I mean, what a weird thing to say. Jerry Holman's like, I'm not on video. And Richard Allen's like, neither am I. Jerry Holman, 4 or 5 witnesses didn't see me out there. Rick, me either. Jerry Holman, my round out of my gun wasn't 6 inches away from a dead girl. Rick, mine neither. Jerry, I don't think you're a bad person. Okay. It's like aggressive, and it's like, hey, I don't think you're a bad person. And then Richard Allen says, what kind of good person kills 2 people? Again, you could look at that many different ways. I just wish we could see it. We're just reading it, right? Little bits of it as well. I wish we could see the whole interview. One day we probably will be able to, depending on what happens at the trial. But, you know, there when he says, what kind of good person kills 2 people? He's challenging, in my opinion, what Jerry's saying. I don't think you're a bad person. He's like, what kind of good person kills 2 people? What are you saying? You're trying to say that I did this? That I killed 2, actually children, but people? And now you're telling me I'm not a bad person? Right? Stefan's like, maybe Holman is in that video. Rochelle says, TV shows unfortunately depict certain things in the wrong way, making viewers believe that's the way it's done. Yes. I mean, yeah. That we understand, right? It's funny how Jerry was like, this is realistic. Okay? Rick Allen, you're following me? It's realistic over here. So then he says, wait. Richard Allen, as we'd say in South Africa, he strips his muria now, which means he's getting angry. I would, if in his shoes too, you'd be like, wait, what? So Rick says, mine either, right? I don't think you're a bad person. What kind of person kills 2 people? What kind of good person, right? Rick Allen, you're going to pay for what you've done to my wife. You want to F with me? F with me. But you leave my wife out of this. Leave me out of this. See, they stripped his murder. Jerry, no, you're involved in this. Your effing round is there, Rick. No, it's not. Jerry, you're guilty of something. You're guilty and I know it, and I'm going to effing prove it. You see, you're guilty of something. You're involved. Your round was there. He never says that he's the killer. You know what I mean? We know what you did to those girls or that you killed it. He's just like, you out there. And they don't know what else happened out there. Yeah, clearly. Jennifer says, let Holman speak like that on the stand. He's bound to offend someone. Sarah Sunshine says, I would like to see Holman on the behavior panel. Yes, I vote for that as well. Stephanie says he's using distancing language. He can't even call them children. And then, let's see what else you say. Rob says, if you remove all the F-bombs, the document would be a hell of a shorter. So, here they give examples again of another case. Police questioning of ER was prolonged, lasting almost an hour. The questioning was sustained and relatively drawn out, especially compared to roadside traffic stop questioning. Holman's questioning of Rick Allen was nearly 3 times longer than law enforcement questioned ER. But, you know, Holman's prolonged questioning lasted 2 hours and 41 minutes. We've seen longer. You know? So Holman's prolonged questioning, 2 hours, 41 minutes. Of course, that represents the length of the questioning that was actually videotaped. Since there's missing videotape, the entire length of the questioning is unknown. But earlier they said a couple of minutes, so I don't know. The questioning was sustained and drawn out over that time, especially when compared to roadside traffic stop questioning. Miss Smith says, you're involved in something and I'm going to prove it. Sounds like they have reasonable doubt too. Yeah, it does sound like they have reasonable doubt too. So here they're comparing again this case, another case with Richard Allen. The officers continue the interrogation of ER. After he was supposed to pick up his daughter, Rick went to the station to pick up his vehicle, but Holman never mentioned anything about where or how Rick or his wife went to pick up the car. At the conclusion of the interrogation, ER was allowed to leave and return home. The fact is mentioned of the Court of Appeals opinion, but not Supreme Court opinion. Rick Allen was not free to leave as he was handcuffed and arrested on camera after over 2 hours and 40 minutes of denying involvement in the murders. The facts involving Holman's handling of Rick Allen's interrogation are more egregious than those facts in ER in several ways. So, I think I just really wanted to go over that interrogation part there with you. Right, so they said the videotaped statement of Rick Allen provides a whole host of evidence, as detailed herein, that statements made by Rick Allen on the day in question violated both his state and federal constitutional rights against self-incrimination. Wherefore, the accused, Rick Allen, requested this court to suppress all statements made by Rick Allen at his October 26, 2022 interrogation and to issue a finding that Jerry Holman and the state police violated Rick Allen's constitutional rights. Which earlier, as we said, McClellan was like, denied. Well, he's objecting to it. Judge Gold will have to decide what she'll do with that. But yes. So, let me just see. Simply said, didn't they also put loads of crap that's completely irrelevant to the case in the discovery dump, probably to bog down the defense? Yep, we went over that at the beginning of this stream. Yes, indeed they did, which is, so that's some very odd things that they said in that document, right? Like, including in the document what appears to be a dead guy in a bed and police turning them over. Like, what is going on? Was it this one? Yeah, it was in this document that we went over. That one, and then something about a third-party suspect in Manatee, Florida, and some guy with bloody jeans. Like, what is going on? Sure. So, I'm glad that we got to do a round 2 of this and actually see the document. To the members, I'm going to just delay our member stream a bit because, as you know, on YouTube, well, maybe you don't know, let me tell you, YouTubers get 3 notifications. Okay, so you are subscribed, right? There's 3 notifications per content creator per 24 hours. So if there's breaking news or something, if we now had a member stream, because we had a glitchy one, this new stream, if we had a member stream now, and we have that, and then there's breaking news, you'll miss that next notification, unfortunately. So I'm just going to hold off on that. Maybe we'll do tomorrow. Maybe later if nothing happens, today. We're just keeping an eye on some, always, as always, in true crime, it never sleeps and you never know when there's breaking news, right? So I'll keep you posted. Please check out my YouTube shorts, check out my community tab, because I'm always keeping you all posted on there as well on many other cases. Today we looked at, Stefan Stones that was supposed to be in court and all of that. So I made a short and a community post and talked about it on Patreon. So go check that out. If you want more behind the scenes content or little videos from me or whatever like that, podcast episodes, voice clips, whatever you want to call them, pictures, it's all on Patreon. So if you are on Patreon, I uploaded a video for you today and I hope that you got to see that. So, Richardson family says, thanks for coming back for round 2. It is my pleasure. I had to fight with my computer, the Wi-Fi, Bill Gates, and YouTube. Okay. I think we won the fight today. We managed to do the stream. Look at all these new documents. 19 days to go until the trial. I'm sure there's still going to be a lot of, spanners in the works here. I don't know if it's going to start on May 13th. If it does, great. I hope then it's a smooth trial and that nothing will go wrong, that it's a fair trial, and let's see what the jury decides. So, I'll keep you posted. Thank you so much. And Scott says, bye, chat. Lovely chatting with you. Thanks all for being here. Thank you, mods. See you again soon. Bye.